We are picking up with the third video for Chapter 7. Picking up with Federal Rules of Civil Procedure, Rule 26. And Rule 26 deals with discovery, and it's the fact that at your initial meeting, the scheduling conference, or within 10 days, you need to, or the attorney needs to be disclosing certain information, and not waiting around to be asked for it by the other side. You know, what type and amount of damages you're claiming and how you came to that number. Copies of insurance policies, things like that, that you know you're going to have to disclose, so you might as well go ahead and get it done and develop a good relationship. If you fail to disclose things that you are required to disclose, there's sanctions. You might not be able to use that piece of evidence at trial. You may have to pay reasonable expenses, pay attorney's fees. So you want to work, or your supervising attorney, and you may be with them, needs to work at that initial scheduling conference with the other attorneys to come up with a reasonable schedule. And as you're going through, you're also going to be required to disclose information about expert witnesses that you might use, their names, their qualifications, how much you're paying them, and other disclosures. You've got to list all of your witnesses that you're going to call, list of the witnesses with their deposition testimony, exhibits, and most of that's going to have to be done at least 30 days before trial starts. Okay, now next big area is discovery of electronic evidence, and that certainly is taking up a large amount of discovery in these days. And so number one, you have to be able to be proficient about sorting through that electronic evidence, searching it, finding the information that you need. Keep in mind about things like metadata, the hidden data within a document, that can many times be a smoking gun when you see when particular documents were created, or when they were modified. You also are going through lots and lots of emails. Don't be deleting files. And on the other side, if someone has deleted files, there's so much we can do now to recover it. No need to think that it's completely gone. But on the flip side, that applies to our side as well. And you're talking about not just active files on a computer that's being used, but backup files, external hard drives. There needs to be some system process for backing data up. Sometimes with regard to certain electronic evidence, there are certain special requirements, like having to provide an image copy of particular information, meaning an exact original copy, kind of like if you had to give a certified copy of, let's say, a birth certificate. It's the same type of it's the same concept. You also have to worry about preserving the chain of custody from electronic information from person to person. And you, the paralegal, can end up playing a huge role in that. So this next slide is about not certainly comprehensive, but these are some of the motions that could get filed prior to trial. We've already talked about the motion to dismiss, where the defendant is going to make a motion, sometimes even before answering the complaint, to dismiss for lack of specificity in stating the cause of action or stating a claim for upon which relief can be granted. There is a motion to strike if we want to get rid of particular material from the other person's or the other party's filing. Motion to make more definite and certain, making the plaintiff clarify the cause of action. That one probably is not going to fly so much in a notice pleading state. Motion to compel discovery. Sometimes you're going to have opposing sides that just are not forthcoming with the information, and you have to actually go to the court and ask the judge to force them to disclose certain information. We've talked a little bit about motion on the pleadings after the complaint and the answer have been filed, submitting a motion asking the judge to make a decision just based on the pleadings, because there's no question of fact. It's just about applying the law. And then a motion for summary judgment is going to usually be the last motion before you actually go to trial, where you're asking the judge to, not just on the pleadings, but everything that's been discovered, what information is available, asking the judge to make a decision on the case at that point in time. So then the next, and there are those motions that you can go through and look at. So the next kind of half of the chapter is about the trial itself. The parties in the case can either request a bench trial where it's just a judge, or a jury trial where we actually seat a jury to make decisions of fact. So trials, as we talked in alternative dispute resolution, trials cost a lot of time and money. So if we can find a way to avoid going to trial, we want to do that. If we can have negotiation and come up with a settlement without having to go to court, that is always a winning procedure method. But sometimes we just can't avoid it. Sometimes we move into alternative dispute resolution, the things that we talked about last week. But even as we are working on trying to come up with a settlement, we are still preparing for trial. The paralegal is collecting, organizing documents, creating trial prep checklist. We're still trying to settle, but we've got to be ready for trial. We're going to be contacting witnesses, issuing subpoenas to any witnesses that we're going to call, and preparing those witnesses for trial. Especially, if there's a witness that we are calling that's going to support our side, we want to get them prepped, do some role playing with them, help them get comfortable testifying in court. Usually it's just the unknown. They just don't know what to expect. So we want to tell them about, how they need to dress, how they need to speak, what they need to do. You're not telling them what to say, but you're getting them ready to walk into the courtroom and be comfortable, okay? As comfortable as can be. Nobody's ever really comfortable. We're also going to be working on what exhibits we need to have ready for trial. You want to have professional, organized, good, demonstrative exhibits and displays. It may require that we hire outside vendors to work on it. We may have to make sure that the courtroom has the technology for it. So there's a lot of things getting prepped and ready to do that. Some attorneys, all they want is an easel and a whiteboard, or an easel and a flip chart. And then you're going to have certain attorneys and certain types of cases where you're going to have a lot more elaborate exhibits. So keep that in mind. And I have previously talked a little bit about a trial notebook, making sure that you are maintaining, getting it ready. And this doesn't necessarily have to be a physical book. It could be a OneNote notebook in the computer, or using one of the legal applications that exist, software out there, where you're organizing everything in a binder or in that file so that it can easily be located, relied on, ready for the attorney, whether they're impeaching a witness or pulling up an exhibit or whatever it might be, that they can easily get to it. And has an index or table of contents. Keep in mind, if you do use a physical book, and some attorneys are going to just want a physical book, don't put any original documents in there. You want it to be copies. Courtroom technology. As we're moving forward, especially in larger cities, courtrooms are becoming more and more futuristic, having more technology, having smart courtrooms. The judges, the clerks, they're having things all electronically. They're pulling the files they need electronically, accessing documents quickly. There's sometimes video recording. The court reporters can be using advanced technology. It might be equipped for trial presentation software, where you're putting up, mixed media presentations, diagrams, graphics. It really is kind of the next generation of courtrooms. We've talked a little bit previously about that pre-trial conference. We're probably going to have another one before we actually start the trial. Judge is going to ask us about, can y'all not come up with a resolution, a settlement, an agreement? We're going to talk about how we're going to conduct trial, clarify any issues that are still out there, set up some ground rules. We might have some motions. We call them motions in limine, meaning something that's still outstanding that needs to be addressed. Usually it's going to be about limiting particular evidence. And then as we get ready for trial, we're going to move into the jury selection phase. Now, we could spend an entire course talking about jury selection, and jury consulting is a huge business these days. It's even on TV. If y'all watch the TV show Bull, that's of course a little bit far-fetched as far as the available technology, but it is a huge business. I even have a friend who works for one of the nation's a nationwide firm, and she splits her time. She has traditional paralegal duties, makes up half of her job description. The other half deals with their jury consulting piece within their firm, and she works on compiling the statistics from mock juries. It's, you know, the other half of her job is about jury selection. So what happens is there'll be a panel of jurors that have been assembled, and every jurisdiction may be a little different of how they develop that pool of jurors. Usually it's going to be registered voters, something along those lines, and they're going to pull a certain number randomly, and they may go as far as having, you know, an actual physical bucket they're pulling names out of. Usually, you know, by now they've got some electronic program that is going to, software that's going to do that, and they're going to get randomly selected. They're going to be sent a jury summons in the mail, and they're going to gather at the courthouse at whatever is the specified time, or they're going to call in at a certain time and be told when and where to report. And once we get that pool there, we're going to go through a process of selection, and it can go different ways depending on the judge and the jurisdiction. So some types of trials require that you have a 12-person jury. Sometimes it's as little as 6, and it's not just civil matters that can have 6. My husband was recently on a jury for a DUI that was a 6-person jury, so it can be in criminal as well. So the process of selecting a jury is called voir dire. That's the process we need to go through, where we're going to be asking those potential prospective jurors some questions. Now, it might be that in the beginning, when the jurors report, that the judge is going to ask some general questions to try to weed out certain people. Usually they're going to be pretty strict about who they're going to dismiss at that point, but they're going to get, you know, general biases out of the way, things like, you know, related to someone, either defendant or plaintiff or one of the attorneys, and we're going to deal with that. And then usually we move to where the attorneys are actually asking questions. And this is a very critical step in the trial. Sometimes it you know, can determine an outcome at the very beginning. And so you need to be helping your attorney, number one, isolate what would be the perfect juror, the ideal juror for this case. If this is a huge business, as I said, you know, depending upon how much money is at stake, we may be paying to have an outside jury consultant come in, but we want to help our attorneys be prepared, have all the information that we can possibly uncover. We want to make sure that we are, you know, our ultimate goal is to uncover any biases that a particular juror might have. We're going to be doing things like, you know, checking out that person's online, their digital shadow, to find out if we can glean any information. Usually we're going to have a very limited amount of information that we're going to be given at the beginning about this potential juror, usually just name, address, maybe occupation, marital status, that kind of thing. But our goals in asking questions are going to be to uncover biases, and depending upon the type of trial, the publicity it's received, this jury selection process could go on for a good period of time. Okay. So one of the things that will be decided at that pre-trial conference is about how many challenges we're going to agree to. Okay, so there are these things called preemptory challenges, and those are people that we can, whether we're plaintiff or defendant, we can dismiss as potential jurors. We can dismiss them without giving any reason why. Okay, and you only have a certain number of those. So you really want to get, if you just really need to get rid of a juror, you want to do it for cause. You want to be able to say that they have a certain bias that is going to hurt, injure our side. So we want them to get dismissed for cause because that doesn't count against us. But if we are not able to do that, but we just know this is not a juror that we want, they are, you know, maybe this is a automobile accident and we're the defendant and this person has been in multiple catastrophic accidents, car accidents that have caused injury. You know, we probably don't want that person and we can dismiss them without cause. But we want to try to do it through a challenge for cause versus that preemptory. And your role, what can your role be during this? Well, you can help the attorney establish what would be that ideal juror, what would that juror profile be, help them draft the questions they're going to ask to help uncover biases. If you're there during jury selection, you're another pair of eyes and ears that you can observe and see things that the attorney can't, very much like when you go, let's say, to the doctor with someone, how they can't process that information because it's happening to them. They need someone else there to hear exactly what the doctors are saying and what our next step is. So it's the same type of situation. And you can sit and observe without being as conspicuous as the attorney themselves would be, and then report that to your attorney. There will also be certain alternate jurors that will be, depending on the case and how long is expected to go on. You could have 1 to 3 or more, but sometimes things happen and people cannot continue as a juror. Alternate jurors will stay and will be there to listen for all testimony, and they are only dismissed once deliberations begin. So if you know, no one else drops out and deliberations begin, those alternates are going to be free to go. So as we are getting ready for trial, we've got that the jury selected. You're still assembling documents and materials that we're going to need. You're always going to be, you know, a step ahead of what we're going to need for the next day for trial. Keeping an eye on where our witnesses are. You know, are they going to be able to be, are they going to be available? Are they in the courthouse at the time we need them there? Staying on top of that, having that relevant deposition transcript summarized and indexed, and at the end of the day, just reviewing what's happened and where we're going the next day.